Welcome and thank you for standing by. At this time, all participants will be in a listen-only mode until the question and answer session. To ask a question at that time, please press star 1. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I would like to introduce your host for today's call, Linda Abruz. You may begin.
Thank you, and good morning for those of you joining on the East and West Coast. Thank you for joining us for a webinar on general prohibitions and end-use and user controls. I'm pleased to note that we have more than 46 people registered for this webinar today. My name is Linda Abruz, and I'm an International Trade Specialist for the Marketing Communications Office for the U.S. Commercial Service at the Department of Commerce. This webinar is being brought to you in cooperation by the U.S. Commercial Service and the Bureau of Industry and Security, and I would like to welcome all the participants in the export community who are joining us from all across the United States to learn about the 10 general prohibitions for all export transactions subject to commerce regulations. In this webinar, you will learn how each prohibition applies to particular exports, re-exports, and other activities subject to the Export Administration regulations, and you also learn about the end-user and end-use controls that apply to any item under regulations. In a moment, I'll turn this presentation over to Sheila Quarterman, who is our Export Policy Analyst of the Regulatory Policy Division. Sheila will be available at the end of the presentation to answer your questions, and contact information can also be provided. Now, for those of you who just joined, you can still log into the webinar by entering the URL, website, and passcode for instructions that were sent to you by email. We do have a few housekeeping details to make sure everyone gets the most benefit from today's webinar. You are able to hear this presentation via your telephone and view it simultaneously via your computer. So if you're not hooked up through both, please take a moment to do this. And if you're experiencing any technical difficulties, please press star 0 anytime during this presentation. We will be taking written and voice questions. To ask a written question, we do invite you to type in your question on your screen as they occur to you. You will find on the upper left-hand side of your screen is an icon with the letters Q and A. You can click on that icon and type in your question anytime during this presentation. We will compile these questions and present them as many as time allows. Type questions which are not answered during this webinar will receive a personal answer via an email. And we also will have in our Q&A session time to ask voice questions. To ask a voice question, please press star 1 and an operator will assist you. We also have a copy of the PowerPoint presentation slides from today's webinar. There is an icon on the upper right-hand side of your computer that looks like there are 3 sheets of paper overlapping one another. If you place your mouse's cursor over this icon, you can actually download the PowerPoint presentation slides to your desktop or to another folder. In addition, all listeners will also be provided with any information for any individual follow-up counseling, export assistance, or market research. And for those of you who just joined us, you can still log in our Internet conference. And now I'd like to introduce live online Sheila Quarterman, who is the Export Policy Analyst of the Regulatory Policy Division of the Bureau of Industry and Security. Sheila, thank you very much for joining us.
Good morning, everyone. I hope this session is catching you alive and well and all enthusiastic about these pleasant and helpful export controls under the Bureau of Industry and Security at the Department of Commerce. Again, my name is Sheila Quarterman. I'm one of the analysts, one of the senior analysts in the Regulatory Policy Division here at the Bureau of Industry and Security. And our function, along with our colleagues who are either providing counseling or providing licensing information, generating licenses, or even those enforcement individuals. But within the Regulatory Policy Division, we are there to help answer questions, interpret amendments, and primarily they refer to us affectionately as the reg writers. What we're going to do today is follow up or continue, I guess, the journey that some of you have taken, and for others of you who are new to what we are doing, we hope to add to your dimension of understanding how and why, what, and when are your requirements under the Export Administration regulations. Okay. Essentially, what you have, and I'm presuming a lot of you have either dealt with this or you're new to this, so what it is, it may be a refresher for some of you, and it might be an introduction for the rest. But no one feel any stress about this, because as time goes on, we're trying to update or at least clarify or simply remind you about some of this information. If you and your activities for your organization have determined that your item and your activity are subject to the Export Administration Regulations, in other words, what you plan to send overseas as in an export or where you plan to send to another foreign country from one to another overseas is within our backyard, within our jurisdiction, and you have also determined that those items not only are in our backyard, they're part of a large group over which we have something to say. You also have found out there's a classification that means you may need a license and authorization with which to move them from one destination to another. In other cases, it may be an item that is subject to the EAR, or better said, within our jurisdiction under the Export Administration Regulations here at the Bureau of Industry and Security, but there's no formal authorization. We also remind you, though, that even in those cases, we want you to be aware of who you're dealing with and what they're going to do with an item, as well as where else they might be planning to send it. So with that information, with that reintroduction of how we get to something as complicated but simple at the same time as the general prohibition, you have determined your item is subject to the EAR and possibly needs authorization. What the general prohibitions are assisting you in doing is restating some of those same guidelines and requirements. It is another way of evaluating your licensing requirements as well as other sorts of authorization or activities that you may need to come to the Bureau to clarify or to establish or basically have something resolved in terms of problems in your export transaction if it or those transactions involve dual-use items to be exported or re-exported overseas. So fundamentally, what we talk about when we mention the general prohibitions, today we will cover general prohibitions 1 through 3, using the reasons for control in the Commerce Country Chart, as well as no license required. Now, that is going to be the focus more so of general prohibitions 1 through 3. Here, there's a diagram. Now, for some, if you're like me, I'm more visual. So we can give you the literal as well as you're hearing this oral presentation, but for many of you, it may be better to have something illustrative, more in a diagram function or format. And what we want you to focus on right now is you look at that top diamond, you've already determined whether your item is subject to the EAR. If it's not, you've exited the EAR or any consideration or evaluation of it. Of course, we remind you there may be other agencies who have jurisdiction over your international trade activity. If your item or your activity is subject to the EAR, then you're dropping to that nice sort of rectangular box there. Is your item classified under an ECCN on the CCL? Is it classified, in other words, under an export control classification number on the Commerce Control List? And right in there you see general prohibitions 1, 2, and 3. Another way of saying that in short form is there a list-based reason under which your item is classified or is brought under our jurisdiction? Because it actually is an item that presumptively is controlled based on its listing on the Commerce Control List, and therefore you likely need an authorization. So look at that rectangle right there, and that's where we will start discussing the general prohibitions 1, 2, and 3. General prohibitions 1 through 3 essentially are telling you, and that's the general prohibitions are set up in sort of an emphatic language that says you may not without a license or license exception. It has already given you the parameters because these items, your activities, are list-based. They are tied to the Commerce Control List, which, as a reminder and a refresher for some of you, is found in Part 774 of the Export Administration Regulations. You may not, without a license or license exception, General Prohibition number 1 tells you export or re-export controlled items to listed countries. General Prohibition 2, you may not, without a license or license exception, re-export foreign-made items incorporating more than de minimis amount of controlled U.S. content. And General Prohibition 3, you may not, without a license or license exception, re-export foreign-produced direct product of U.S. technology or software to a D1 country, primarily this one focuses on Cuba. Now, because we say list-based, if you notice that General Prohibitions 1 through 3, fundamentally you're talking about items that have classification numbers on the Commerce Control List. And that gives you at least a lot more guidance in the sense that you're pretty sure that there's going to be a responsibility for getting authorization. Essentially what we're telling you, the agency has fundamentally done the work for you if the item has been classified properly. And you know, in order to classify an item, a dual-use item that is classified and then found on the Commerce Control List, essentially you can do that yourself, you can go to your manufacturers, or you can come in and ask the agency, the Bureau of Industry and Security, to do it for you. I would look in Part 748 for guidance on how to submit a request for a classification of an item. Now back to the slide we have in front of us, in talking about the Commerce Country Chart, we tie in the country to the Commerce Control List. Essentially, that is helping you understand that when things are list-based, you classify the item, you've gone to the control list, but you want to see if that applies to the destination to which you are going to export or re-export your item. And what we're telling you here is that once you leave the Commerce Control List and you come to Supplement 1 to Part 738 to look at the Commerce Country Chart, if there is an X in the box for the reasons that item is controlled to your destination, then presumptively you likely need a license. There is a license requirement. So if there's an X in the box, it indicates a license requirement. No X in the box indicates no license requirement. But you're doing that coordinated with the classification of an item that appears, and that number appears on the Commerce Control List. Commerce Control List used in tandem with the Commerce Country Chart. And this is an illustration of what we mean by that. Someone has gone to the list, the Commerce Control List. They found their item. The entry of that item has an export control classification number. They've looked at the reasons for control, and you can see the reasons for control on the Commerce Control List are pretty much abbreviated. They will match these abbreviations that you will find on the Commerce Country Chart. You come to the Commerce Country Chart. You look for your destination. Here we have Andorra. And you see if the reason for control of the item that you plan to export is missile technology, abbreviation MT, and you look for your destination, then you can see that there is an X in the box across from Andorra in the column for MT. Presumptively, there would be a license requirement. No license required. You cannot either find your item on the Commerce Control List, or you found it there, but there's no X in the box for the country to which you plan to export it or re-export it. Then we refer to that as no license required. But please keep in mind, your item would need to be first subject to the EAR, and then you're going to classify that item. You're going to look at the specifications to see if it appears on the Commerce Control List. So if you're lucky enough to have an item that is subject to the EAR, but there's no license required to ship it out, then you may use the notation abbreviation NLR. And the various reasons you will use it, or the various cases in which it can be used, would be for EAR 99 items, and we call EAR 99 items that are subject to the EAR, but they don't have a formal export control classification number, the typical 5-digit or character number that you find on the Commerce Control List, but it is subject to the EAR. Or it may have been close in its characteristics to entries on the Commerce Control List, but not enough, as they would say, for a cigar. So we put those in a basket and call all of those EAR 99 items. Or in another case, you can use NLR as a notation, especially for export clearance documents, when the ECCNs, where there is no X on the country chart under the reasons for control. So you found an ECCN on that Commerce Control List. However, the restrictions or the reasons for control for that item when going to your destination didn't apply to that destination. And you can use NLR when the transaction does not require an export license based on any other licensing requirement. And the example we give are end use and user requirements. And we're going to talk more about those later. Right now, the focus is on list-based. In other words, because an item was classified and found on the CCL. Okay. Now, determining license requirements based on ECCN and destination, which is what we're doing when we're dealing with general prohibitions 1 through 3. There's an X in the box, which indicates a license requirement. And when there's no X in the box, it indicates no license requirement. So these are what we call the list-based characters or personality of the general prohibition. There's an express statement of what you cannot do without a license or a license exception if your item is controlled and found on that commerce control list. If your item is above what we call de minimis, which means there's a threshold amount of value of U.S. controlled content in an item, and if you stay at the threshold or below, then your item is what we call not in our backyard. We've just determined that even though it's controlled for those items, if de minimis is available, then we don't control that. It is not subject to the EAR. Or in the other case, when there is list-based or general prohibition number 3, we talk about foreign direct produced product, but that limitation is only applicable to Cuba and D1 countries. And what we're saying there is someone's used technology or intellectual property to create or produce a product overseas, then essentially we would only be concerned about that, or there would be a license requirement if there's certain conditions met, but the primary one is that it's going to Cuba or a D1 country. So general prohibitions 1, 2, and 3 essentially deal with those items that have an ECCN and fall into one of those circumstances. It's on the commerce control list, and it applies to your destination. It is above de minimis, or it is caught by foreign direct produced product rule because it's going to Cuba or a D1 country. Now, there are other reasons that are stated for which you need to be responsible and you need to be aware. Another way of saying how you have licensing requirements, other responsibilities under the EAR, and that is where we start now to deal with general prohibitions 4 through 10, or in other words, end use and end user considerations or requirements or limitations. And that brings us to the second portion, determining other licensing requirements. So as I just mentioned, we've left the list-based or general prohibitions 1 through 3 that are tied to an item that has actually been classified and found on the Commerce Control List. And in some cases, you have that EAR 99 item, the item that is not so specific or well called out on the Commerce Control List, or is generally an item that's dual use, but it's really so general that it's broadly under our jurisdiction or in our backyard, but we don't have generally a license requirement for it. However, that is seemingly innocuous item, and there are other reasons like certain parties to transactions or activities that may come into question, and so what seemingly did not need authorization could turn into a licensable activity or requirement because of what? Who's getting it? That's the end user. What they're going to do with it, that would be the end use. Or there could be questionable parties to the transactions. Or there could be U.S. persons who are involved in prohibited activities, and there could be some questionable or prohibited destinations. So that's what we're going to do now. It is not list-based. It is transaction-based. So the topics here in general prohibitions would be those general prohibitions 4 through 10. Prohibit exports based on knowledge about the transaction, end use, end user, parties to the transaction and activities, screening parties involved in the transaction, prohibited exports to destinations under embargo or with special controls, and other prohibitions. So I'm hoping that you're seeing how this picture is drawn. It is from what we have expressly and objectively set out on our list where we've done all the thinking for you, and it's been classified, and we set forth the requirements. That would be general prohibitions 1 through 3. And now we're coming with this. You're going to have to be a bit more consideration primarily on the part of the exporter, because then you're having to use all the knowledge and all the awareness and details you have about your transaction to see if there's something that would be prohibited under EAR because of who gets an item, what they're going to do with it, where they plan to send it, and perhaps parties to the transaction. All right? Now, I hope that is making sense for you, that we move from list-based to transaction-based. We're back to the chart because we have now, after evaluating the CCL and the general prohibitions as it relates to items that are actually expressly listed and the controls that are expressly stated from the CCL to the country chart, we're dropping a little more below that. And if you look to your left in a shorter or smaller rectangular box, and you look to your right and you see the same sort of box, what it asks you now, do general prohibitions 4 through 10 apply? And essentially, you really should be looking more to the right if we're looking at the screen in the same direction here. And you see where it says EAR 99, and then an arrow drops and says General Prohibitions 4 through 10. Because an EAR 99 item, as if I've explained this correctly and you sort of kept up here, is basically an item where presumptively there's no license requirement. But if there are factors in that transaction that could be questionable or based on end user, destination, and party to the transaction, if there's something questionable there, you turn a non-licensable event into a licensable event. And we're going to evaluate how the general prohibitions sort of guide you through that. General prohibitions 4 through 10, in a nutshell, as stated here, deal with number 4, denial orders, and we're going to talk about these in a little more detail. Number 5, knowledge of end use and end user controls. Number 6, embargo countries. Number 7, U.S. person support or proliferation. Number 8, transit through certain countries. 9, terms or conditions of licenses. And number 10, knowledge of a violation. Now, if I were you, I really would underline that knowledge of a violation. That tends to reach out and grab everything because a lot of what is falls into your lap as a responsibility or that may trigger some liabilities because certain things could happen with regard to 4 through 9, as well as some oversights in other parts of your transaction. And your awareness or your knowledge of these could then move you into closer liability and close proximity up to what might be a violation of the EAR. Why are these considerations important? Because they're awareness of other licensing requirements, and they're important because, as you may have gathered, they go well beyond the Commerce Control List licensing requirements. The licensing requirements are more express, and most of the background work has been done for you, but they affect all items subject to the EAR. On the Commerce Control List with General Prohibitions 1 through 3, we were focusing on the items that have been classified and appear on the Commerce Control List in Part 774 and Supplement 1. When we talk about these General Prohibitions 4 through 10, the transaction-based General Prohibitions, they apply to all items subject to the EAR. They are a critical factor in analyzing and making licensing decisions. They're part of internal control screening. Some controls are specifically based on information that is known to the exporter and re-exporter. So you see how somehow they seem to be all-consuming because the ball falls in your court to fundamentally be aware of who you're dealing with and what types of items you're planning to send and what is going to be done with them. This is how we tended to have more there's more fame to the term the WMDs. There's also a matter of sometimes when in the business world and there's nothing wrong with it. Your primary objective may be to make a profit. That we understand, but we're hoping that it's a legitimate and positive and constructive way of doing business that does not endanger or offend the reasons that we control a lot of items or the reasons that the Export Administration regulations exist. National security, there's some for foreign policy reasons, as well as others that really primarily deal with proliferation, and that really gets back to the weapons of mass destruction. And now things take place in a different form nowadays. So you always hear terms of terrorism and how an item that would otherwise be innocuous can be used for a bad end. So what do we mean by knowledge? And that's why I thought you should underline knowledge, because for everything that was listed, be it a denial order, going to an embargo destination. Your knowledge of where something went wrong or could go wrong in a transaction is very important. If you look in Part 772, the EAR, what we hope you will learn is what we mean by knowledge. And I also want to give you a note that the definition under the EAR primarily is how it should be used as it applies to the Export Administration regulations. We cannot speak for another agency that may use some of the same terms, and we call them perhaps their terms of art for them. So you really should check with other agencies who have jurisdiction over your exports or your international trade activity to be sure that they are defining terms in such a way that you're clear where your responsibility falls to them, as well as how you are responsible under the EAR. Knowledge for our purposes, and you can always go back and check this in Part 772, but here in a nutshell, it includes positive knowledge that a circumstance exists or is substantially certain to occur. You know what that's like? Someone put something in front of you, you read it, you acknowledge it, it is clear to you. It is not presumptively, but as a matter of fact, it has come to your attention and you're fully understood. You're fully understanding it. It also means that there's an awareness of a high probability of its existence or future occurrence. So a positive knowledge is that it's not a sense of things. It is more or less a fact that you have been informed. And awareness is that it makes sense that something's going to occur. And you really are dealing more with a sort of reasonable person basis. And you see below, knowledge equals reason to know equals reason to believe. And that is, you really ought to look at it from a point of view when you're doing your business, there's certain things that come to your attention and then something clicks on. And I always advise that the people in business should use some of the same criteria or the same instincts they use to run a business when they're trying to evaluate or trying to build in screens or other components that apply to regulatory compliance under the EAR. License requirements due to end-use controls in Part 744. That's where the crux and that is the haven for the end-user controls that pertain to General Prohibitions 4 through 10. Remember, these are transaction-based, and they prohibit exports, re-exports, and transfers in country of items for various reasons. And most of these are aimed at proliferation, nuclear, chemical. We include the missile technology. And this is an example of what we mean by the end-use controls. They are primarily found in Part 744. What are the non-proliferation control policies? Essentially, if you were to go to that part of the EAR, and the example here is 744.2, the one that pertains to nuclear end uses would be worded mostly like this. And this is primarily an example of how these provisions exist. This pertains to General Prohibition 5, and that has to do with the end-use controls for proliferation reasons. There are other end-use controls. Again, in General Prohibition 5, we're talking about general prohibitions that have to do with end-user controls, and that would be knowledge of end-use and end-user controls. So the others beside those called out that are traditionally the proliferation types of end-use controls would be maritime nuclear propulsion. We give you a section there. They are worded slightly differently, but what they all have in common is that if they are going to the use as specifically described here, end use or the end user, there are going to be restrictions. There are going to be conditions, but they are worded a little differently. Here we also have certain foreign aircraft or vessels, military end use to the PRC, that's the People's Republic of China. In that one, that's a primary example of where the control is end-use based, not end-user. And what your responsibility, but however narrow it is that if there's an item which is also listed in a supplement in Part 744, if your item is listed in Supplement 2, I believe, to Part 744, it is going to the People's Republic of China, to the PRC, and you know at the time of export, it is going to be used for military end use, as we define military end use for these purposes, then you might want to come in. It's a good idea for you to come in and see if there's a license requirement. But that is narrowly tailored for that particular purpose, but it is an in-use control. Again, there's another example here for microprocessors to military end users and uses. So what I'm really emphasizing is that you have to read these control policies very carefully. All of these pertain to the general prohibition that has to do with your knowledge of a particular type of end use and end user as we set forth in the appropriate or applicable provisions of the EAR. License requirements due to support of proliferation activities. Now, here we really put an emphasis on U.S. persons. If you look at 744.6, we follow the item, and even foreign persons can be caught by what we do under the EAR. But again, in Prohibitions 4 through 10, it is transaction-based, so it's the factors involved in your transaction. U.S. persons are called out, particularly in General Prohibition 7, because we don't want U.S. persons facilitating or helping in any way to engage in a proliferation activity. Okay, so U.S. person may not support an export, re-export, or transfer in country related to a proliferation activity. It includes items that are subject to the EAR, U.S. and foreign origin items. Support includes financing, transportation, or forwarding. It can be also the performance of a contract, service, or employment. So you can see how we are actually trying to make it as clear as possible. We really are against U.S. persons trying to engage in proliferation activities that obviously would harm or offend our reasons for controlling items or the interests of the United States. We define U.S. persons in Part 744, and here is a summary of how we define that. Any person in the United States, U.S. citizens, permanent resident, aliens, or protected individuals wherever located, U.S. organized firms and their branches. And that definition is a little more detailed, obviously, if you were to go to Part 772, but the provision that catches U.S. persons is in Part 744. 744.6 for the provision itself, but the definition of U.S. person also is in Part 772. That's where our definitions, that's our glossary is in the EAR in Part 772. Now, we've talked about these end-user controls, General Prohibitions 4 through 10, the transaction-based controls, and we try to help out here by saying if you're trying to look out for the end user, if you're trying to make sure you're not dealing with a bad party to a transaction, we provide this list of the most important, we think probably the most important but not all-inclusive list that you should be aware of and have some way of investigating or reviewing if you're screening your transactions. Now, you may not have an absolute requirement under the EAR for screening, but I think most of us would agree it's better safe than sorry to put a system in place if you have items that are under some agency's jurisdiction. Today, we are focusing on the Bureau of Industry and Security and Export Control, Export Administration regulations. So what we advise you here, and we hope it will help, when it comes to denied parties, there's a denied parties list. There's also the entity list. There's the unverified list. There are lists generated by the Office of Foreign Assets Control. We usually refer to those as specially designated persons. There's a nonproliferation sanctions list and a debarred list. And just as a quick note, denied persons, the entity list, the unverified list are all lists that really are under the control of the Department of Commerce, the Bureau of Industry and Security. OFAC list and the special designated persons really under the jurisdiction of Treasury, but we will provide a link. The nonproliferation sanctions list is close to our, I believe, our entity list under the EAR, but the last two lists belong under the Department of State, nonproliferation sanctions and debarred list. Okay, so the debarred list would be, I think, close to denied persons, and the nonproliferation sanctions would be close to our entity list. But we're going to talk a little more about this. But if you were looking for OFAC list, we can give you a link, but we do not control nor update that list. And the last two here are really under the Department of State, and we can give you a link to them, but we do not control their list. Who are denied persons? Parties denied export privileges under denial order. Now, we talk about standard denial orders, and there are others. Standard denial orders essentially expressly state that, either all or some privileges may be gone, or there may be some special terms and conditions, but these are terms generated by our enforcement office, the Office of Export Enforcement, which is one half or another arm of the Bureau of Industry and Security, where there's export administration and there's export enforcement. Now, one thing about these denial orders that you can be sure, regardless of how that denial order is worded, it means that there are export privileges that have been denied, and under the conditions or terms set out in those orders would be the extent of which and how long those privileges apply to persons indicated. And denial orders are what we say very hard, if impossible, to overcome. Some of you have heard about license exceptions. There are license requirements, and sometimes it's de minimis or other exemptions don't apply. You immediately look to license exceptions so you don't have to get a license. But what we're saying with regard to denied persons and denial orders, you cannot overcome the denial orders. You have to wait until they fundamentally have been removed or the terms have been met. If you have really detailed questions about denial orders, you may contact our Office of Export Enforcement, and that information can be found on our website. This is an example of what this denied persons list, how it appears. Fundamentally, it is kept updated on our website. There is a section in the EAR where you can find information about denied persons, but the active enforced list for your convenience is found on the website. Okay? What is the entity list? Now, entity lists are lists of foreign persons in certain countries who have been known to or found to be engaged or affiliated with proliferation activities, proliferation of weapons of mass destruction. And now, with an expansion on how persons may be listed on the entity list, we also include persons who have been found to be acting contrary to the national security or foreign policy interests of the United States. What you need to understand about this list, you need to look at the list very carefully, Supplement 4 to Part 744, because it may not be all-consuming. Some of these parties are, their restrictions or the caution we give you about the license requirements is that it may apply to all items subject to the EAR, but in some cases it may be restricted to items, only those on the Commerce Control List, list-based versus all items subject to the EAR. This is an example of the entity list. And this, again, can be found in Supplement number 4 to Part 744. It is arranged by country and then in alphabetical order otherwise with the names of the entities themselves. And you'll notice there's a column for the license requirement, the license review policy, and the Federal Register notice that put it into effect. Now, when we say license requirement, it's telling you the scope. Does it cover all items subject to the EAR, or is it only items on the Commerce Control List? The license review policy is telling you once you apply for the license, what is the likelihood of having it approved? What is the unverified list? Again, these last three we've been talking about are under our jurisdiction, the Bureau of Industry and Security. This third one right here, what is the unverified list? It is actually more of a motivator than anything else. It does not have the same force as the entity list or the denied parties list. It is a list that was developed in response to some difficulties enforcement and affiliated parties have had in trying to do what we call a successfully complete post-shipment verifications or pre-license checks. It is now serving a purpose of a red flag. In other words, the ability to alert you that there may be some caution or you may want to give a second thought to dealing with certain parties. It is updated on the website. It's not really an official part of the EAR, but is now used as a tool to bring awareness to our constituents and those in the international trade community, but it does not have the same force as the entity list or the denied parties list. And this is how this list looks on our website. Everything we're talking about now can be found on BIS's website. And that is, of course, www.bis.doc.gov. And there's a plethora of information there, tutorials, all great things appear on the BIS official website. What are red flags? In Supplement 3 to Part 732, and you can read that at your leisure. But what we want to give you is that sometimes we want to give you a little guidance that says when you're dealing with somebody, if it doesn't feel right, doesn't sound right, if it goes against tradition with old customers, or there's new customer and there are terms that they want or questions they're asking that don't fit with your experience, that's one way that red flags appear that will help you decide whether you want to, be further engaged or, take on a new client. So what are we telling you here? Possible indicators that an unlawful diversion might be planned by the customer. Abnormal or suspicious circumstances. Product capabilities do not fit buyer's business. Buyer evasive about destination or use. Routine on-site services is declined. Now, these are not comprehensive, but we hope that they'll bring to mind or help you visualize. And when you're talking to somebody, you say, yeah, I had a potential customer. I had an old customer who started acting a little differently. In Supplement 3 to 732, we explain how red flags fit into some decision-making you must make regarding engaging in a transaction. And it gives you guidance as to, what course you might want to take. But it's really meant to help you let things be triggered so that you can make some informed decisions about engaging or continuing in a transaction under the EAR. And remember, this is about dual-use items. This is about the jurisdiction of the Export Administration regulations. We cannot say that the same terms or conditions or guidance would apply to every other agency who has export, re-export, or international trade jurisdiction. Know your customer guidance. Again, this is still part of Supplement 3 to Part 732. What it's telling you, if you know your customers well enough to know how to be sure to get paid, and that's not a dig, that's just to explain how you want to perhaps put it in context of what you do as a business person. Or there may be those of you in the government community who are dealing with businesses, and we're also advising that perhaps what we're saying to people is that if you use the same sort of criteria and caution or carefulness that you do in generating business to make sure that your company is solvent, then you might want to apply those same criteria, habits, or traditions to making sure that you comply with the Export Administration regulations. Knowing your customer, same thing in getting paid, and also someone who might put your business in jeopardy. You decide whether there are red flags. If there are red flags, you can inquire. The most important line on here is do not self-blind. Don't turn your face and tell somebody, don't say that to me. Don't show me that. That you don't want to do. If something goes wrong, you just don't want to be put in a position that someone says, well, I told them, or they should have known. That's an important point to underline. Reevaluate the transaction. And, of course, we do feel that it's fair to say, absent red flags of special EAR provisions, there is no affirmative duty to go behind customers' representation. But as I said earlier, sometimes, it's better safe than sorry. License requirements due to a country sanction under the EAR, and we don't have much further to go here. General Prohibition number 6 pertains to not engaging in, at least to the extent prohibited, in transactions that will lead your items or your activities into comprehensively embargoed, sanctions, or otherwise sanctioned or restricted destinations. And here we've divided them up for you because now we have comprehensive embargoes. The ones that are most prominent would be for Iran, Cuba, and Sudan. Sanctions, but under special sort of sanctions, would be Syria and North Korea. Even though they are comprehensively embargoed, the circumstances under which those happen are a little more complicated, sometimes very difficult to explain, but they may be moved, conditions may change, but they are still otherwise comprehensively embargoed, but we refer to them as sanctioned because of certain activities. And there are UN arms embargo. It may be fair to say, and I think we may have to update those for Rwanda. They have either been reduced or removed, and we will find out about those later under the UN, because essentially arms embargoes are not necessarily the least important. But under the EAR, where you have the destination has once been comprehensively embargoed, or it is under highly restricted guidelines, the UN arms embargo is not unimportant, but it shows you that there may have been a reduction in the level of the scope of an embargo. So for those of you who remember how comprehensively embargoed Iraq once was, right now one of the last vestiges of an embargo under the EAR for Iraq is the UN arms embargo. So you can read those carefully. And under General Prohibition number 6, it essentially is saying without a license exception, or not so much a license exception, but definitely in most cases you need a license to export or re-export to a comprehensively embargoed destination or otherwise sanctioned destinations under the EAR. So I would look at General Prohibition number 6. We'll talk about this just a few seconds more. Here we have a chart we hope that helps you out a little. We don't always know if it makes it exceptionally clear, but we hope that it makes clear enough as to who you need to go to regarding these destinations. And let me run through this. For Cuba, we have licensing jurisdiction at the Bureau of Industry and Security for most items, exports and re-exports. But when it comes to the financial and personal travel, as many of you probably already know, that belongs under the Office of Foreign Assets and Control at the Department of the Treasury. When it comes to Iran, this is probably one of the most complicated licensing issues that we can come up with. But let's put it in a nutshell. Everything essentially needs to go to the Office of Foreign Assets Control. We fundamentally here at the Bureau of Industry and Security supply them with classification guidance, and there may be one area in which if we had a license requirement, if we required a license for it, would be under this re-exports of EAR 99 items to Iran by non-U.S. persons. I can talk to most of you offline and probably a little more detail, and we can pontificate on that. But what it's saying, if we required a license, that would be the lone area where we would be able to, as close as possible, independently license or evaluate an application. Otherwise, if it's Iran, you are required to go to the Office of Foreign Assets Control. And if you go there, what we're saying, their evaluation and their decisions regarding your transaction will satisfy us. So if you want to read more about that, and I would then go to Part 746, where all of these embargoes and provisions of them are well stated. Now, Sudan, we say here the complicated nature of this is that we have not fully implemented the embargo on Sudan. So you have a dual license requirement. That's sort of a play on words because we are responsible for dual-use items. But what we're saying here, you have to go to both agencies, both Bureau of Industry and Security and the Office of Foreign Assets Control. And that's primarily because we have not fully implemented the embargo. Fundamentally, though, there should not be a whole lot of problems with Sudan if you're very clear. But, again, you have the EAR 99 items. You have items that are CCL-based. Syria is comprehensively embargoed. All items to Syria are going to need a license except for a very, very, very narrow few, and those would be food, EAR 99 medicine, and a narrow area of the deemed exports, that is based on more of an intellectual property arena. But essentially, almost everything needs a license to Syria. There are some areas that are carved out where a license is required, but at least there's a more lenient policy review for those licenses. And North Korea is comprehensively embargoed, except for some food and items, humanitarian items. And most of these can be found in Part 746. Another thing which is a clue about these embargo destinations is that they are self-contained. Even license exceptions, if they're not listed in the section for the individual destinations, then I would not really look elsewhere. And that's why these comprehensive embargoes or other sanctions on these destinations are pretty special under the EAR. They are pretty much special controls. Other prohibitions, and we're almost through, pertain to in-transit shipments. That would be your General Prohibition number 8. There are certain destinations to which you just can't move an item or having going through or have it consigned to the destination to actually then go to someplace else. Also, violation of orders, terms, and conditions. That would be General Prohibition 9. And back to acting with knowledge. Knowledge, General Prohibition 10. Acting with knowledge that a violation of the EAR will occur or has occurred. Some in-transit shipments are prohibited, and here this is an updated list. Many of you may, get whiplash. Your neck will probably just snap back and say, what? because you may look at these and say, is this the Cold War? This list has been updated somewhat, but I think there's going to be a review in the agency to see how it may be better updated. But for now, in-transit shipments and items to be unladed from vessels or aircraft through these destinations would be a no-go. Okay? Orders, terms, and conditions, we've also told you that it's hard to overcome, impossible to overcome orders, terms, and conditions that relate to things like denial orders. So you may not violate terms or conditions of a license or license exception. Any order under the EAR, supplement numbers 1 and 2 to Part 736 contains certain general and administrative orders. So if there are orders coming out from us, which obviously is more of an enforcement function, they are nearly impossible to overcome unless they have been rescinded, retracted, or changed, or have run their course based on the conditions in them. Acting with knowledge, one more time, you may not proceed with transactions with knowledge that a violation has occurred or is about to occur. It relates to any item subject to the EAR. Remember that? All items. Exports, re-exports, activities, financing, transferring, transporting, forwarding, and I'm only naming a few of those that are called out in General Prohibition 10. So our summary, most importantly, we've gone from General Prohibitions 1 through 3, which are list-based. They are based on a classification of an item that appears on the CCL, and unless there are a couple of other circumstances, you want to make sure there's no X in the box. Then when you get to Prohibitions 4 through 10, you're really looking at your responsibility to evaluate very carefully with the information, the valuable information you have in hand of the facts and the parties, end user activities and destinations. This is transaction-based. And this is where you probably, if you feel a burden at all, where you're going to have to really be more comprehensively aware of what you're doing as it relates to items and activities that fall under the EAR. So what we note here, the various lists, the various policies as they refer to certain destinations, and we hope that what we've been able to do is cross-reference some of what you've already understood about the EAR. Here's a little extra note for you. If I've lost you here today, please, please take your time and peruse Part 736 of the EAR, and you'll see all the general prohibitions in there. You also might want to go back to Part 732, which is a wonderful outline of how to navigate the EAR, and it tells you how to approach these general prohibitions. I hope this has helped. It's been my pleasure. This is Sheila Quarterman from Regs Policy of BIS, and as it relates to this formal portion of the presentation, I hope you've learned something because we are here to help. Take care.
Thank you very much, Sheila. Now we'll have a sampling of our voice questions. If you'd like to ask a voice question, please press *1 on your telephone.
Once again, if you would like to ask a question, please press *1.
We have a written question here from Jean Burkhead. The question is, unverified list. Please explain what this consists of, and we'll answer that while we're waiting for voice questions. Okay.
Okay.
Go ahead, Sheila. This is from Jean. She wants to know unverified list. Can you please explain what this unverified list consists of?
Okay. Jean, if you would go to, I'm not sure which page or which number slide this is, but we had a slide that gave you the little picture of the unverified list on our website. And what it showed you was an example of a September 10, 2008 version of the list. And the best way to explain it is, now remember, these are parties where our enforcement people could not successfully complete a pre-license check or post-shipment verification. So before a license was issued, they wanted to go and make sure that the parties were where they said they were and did what they claimed was to be done with an item And a post-shipment verification, obviously, is that something's already gone over, and we want to make sure it got to where we said it should have gone. But in this chart, you'll see you'll get the name of the party, you'll get the country, which is the destination, and you'll get the last known address. And that information is to help people identify the party that maybe our enforcement people think might be a little shaky. So you can go to that screen, and, of course, if you have any more questions, you can call us or send us an email.
Okay. Is it in this presentation?
Yes.
Okay. We'll go to it just to show her. There it is.
There.
Okay.
Right there.
Okay, great. Once again, if you have a voice question or you have a written question, please submit them. To ask a voice question, please press *1. And to ask a written question, on the upper left-hand side of your computer is a Q&A, the letters Q&A. If you go to that icon, you can put your cursor over that and then type in a question for the field that is available.
Hey, excuse me, I do have a question from Jean. One moment, I'll open her line. Jean, your line is open.
We'd like to know, what is a D1 country?
Oh, okay. Can they hear now?
Yes, Sheila,
okay.
You're on.
Now, if we were in part, okay, this is Sheila, and thanks for the question. And we can understand sometimes there's got to be some method to the madness. If you were looking in Supplement 1 to Part 740 of the Export Administration Regulations, you would see a country group D country. Now, a country group D country is one where there are concerns for various proliferation activities. And column or country D1 would be those concerns for national security reasons. And that, for many of us, really pertains to what is more the traditional sort of concerns of threats, whereas when you have D2, it's for nuclear activity, D3, chemical and biological, and D4, missile technology activity. But national security is more about, traditional warfare, or someone who may be armed and better able to, or has more inclinations to engage in offenses or harm to the United States on traditional terms versus this new world of proliferation. But you can find, if you look in Supplement 1 to Part 740, you look at countries Group D, you'll have an A, B, C, and D, and those are countries of concern for those various reasons, and D1 is for national security.
Thank you.
Thanks, Jean, for your question.
I have no further questions at this time.
Okay, and we'll go see if we have any more questions on the written portion. We do. Next question looks like it's from Jean Bolson. Another. Okay, she was another Jean Burkhead. Is it sufficient to notify a customer that a license is required for re-export to another destination if you have knowledge of their intent to re-export, or must you apply for the license?
Right. Okay, thanks for that. I know those circumstances apply all the time. I think it's wise that you can tell your customer or whoever your colleague is in the international realm that, here are these items, make them aware, of course, that these items are under the jurisdiction of the Department of Commerce, and they might need authorization if you're going to re-export. You may offer to apply for them if you want, or you can just make sure they have the information and make sure you keep that in your file. Now, if you don't trust them, what would you think? If you don't trust them and you know the item is definitely going to need a license to another destination, I'm not saying take on the burden, but, if it will, in the end, be lesser burden to do that paperwork or do whatever you need to do electronically than to have something go wrong and try to explain it, that would be my advice to you, to probably take the path of least liability. But I'm not saying you're so obligated, but in the transaction, you're not obligated to apply for the license for them. But you want to make sure they're well aware that they may have some information, and you can show that you have given them all the information and directed them to the right sources.
Great. Thank you, Sheila.
Okay.
Next question here is from Arlene Sosi.
Right.
Does a person from a firm providing technology to a country that he is allowed to, without a license, allowed to transit through the countries listed under the no transit list of countries.
Okay, now, I'll make sure I'm gathering the whole point of your question now. So I have the potential export of technology. So now let's back up and make sure that we clarify that. When technology is sent, because an actual export for our purposes is an actual shipment of an item, and an item under the EAR is either hardware, software, or technology. That's just, you back it up. I hope others aren't bored with me trying to do that. I just want to make sure that we're clear what we call an item. Technology is an item. You can actually send technology by blueprints. You can send it by paper. You can send it by FedEx or however, mode you send it. That's an actual shipment. But you may also send something electronically. Now, the point is, if you know you're sending it to a certain destination, your concern should be relatively broad, not only about in transit, but actually the destination. Now, in transit, I think we may have to talk a little more one-on-one. I don't think in transit shipment of technology is a huge issue for us, because if something's going electronically, unless you sent a hard copy of the blueprint of the intellectual property, then it's going to where you sent it. Unless you have a colleague in London and then you have another colleague in Paris, then it's going to them at the same time. So why don't we talk a little to see if we're really answering your question, because I don't think in-transit shipments is going to be a huge issue for shipment of technology.
Okay, thank you. Looks like there are no more written questions. Okay, then we'll open the line one more time for voice questions. If you have a voice question, press *1. And just to reiterate, this is one webinar of a series of 8. This is normally a 2-day conference topic of a series of information, and this is a great opportunity to ask any questions you have about this topic now. Sheila is here, and she's doing a great job trying to help you guys out. So once again, if you have a voice question or written question, please let us know, and you can do it by pressing *1 on your telephone or writing on the Q&A icon on your computer.
Okay, we do have a question. The question comes from Arlene. Arlene, your line is open.
Yeah, hi. I just had a follow-up question about the export of technology. If we have individuals in our firm who are providing technology as it's defined under items to South Korea, and it's not subject to a license, and that individual, 2 scenarios, is providing the technology and is going to South Korea and has to go through Russia, for instance, would that be an issue? And scenario 2, what if they're carrying blueprints, et cetera, with them, and they're going through, again, a country like Russia, which is on that list, to South Korea? Would that be an issue? Would it be an issue in either of these 2 scenarios?
Okay. Didn't mean to interrupt you. Okay. Let me see if I can answer this one for you. What we're looking at, I know sometimes technology seems to be, because many people think of technology as something so intangible, but if you're actually using blueprints, for our purposes, that's going to be a tangible item. Of course, its value is in its intellectual transfer. And what we're saying is that if you know that once it leaves the United States, it's going to be actually shipped to South Korea. You've evaluated, first of all, that it belongs under the EAR. It's under the Export Administration regulations in terms of subject to. You also may have found that that bit of information may be licensable. So you evaluated its movement from the United States to South Korea. Then you say, oh, once we get it to South Korea, we're going to send the same, we actually are going to move the same bit of information in tangible form to Russia. Then what you probably needed to have evaluated when it came to leaving the United States is whether it needed a re-export authorization from South Korea to Russia. When it comes to in-transit shipments, even if it's technology, if it is hard copy or it's tangible, and it's going through one of those destinations, consigned to that destination, it's going to offload, even though it's going someplace else, my guidance would be I would check to see if there's going to be a license requirement, because what you're telling me is going to stop off, and I don't know what's really going to happen to it between South Korea and then going to Russia. So if it is going there, it's either going to Russia or it's going to stop in Russia. I would come in and then get some guidance on your license requirements, just as it would be if you were sending a chair or you were sending a high-performance computer to Russia, then you want to evaluate it the same way. But you can come in for guidance on that, because then you want to offer as many specific details as possible.
Could I just have a follow-up on that?
Sure.
If in a specific scenario, if it's just an individual who's carrying the blueprints with them for a meeting to South Korea and has a stopover in Russia, would that be an issue?
That could be an issue. Again, we do have some license exceptions now. For example, you can look into this one to see if it fits your scenario. Because if I'm going to give you something closer to an advisory, I probably want to talk to you more offline so you can give me specifics of your business. Some things you might want to share and you might not. But you might want to look at if the information or the blueprints themselves were controlled under the Export Administration regulations.
Okay. In our scenario, if they're not, as far as they're going to South Korea, so if they're not controlled for the end destination, and this is just like a layover for an hour for a connecting flight,
well,
would that be an issue? And also, if the person doesn't have it on them, but they're the person providing the advice, it's in their head essentially, would that be an issue?
They're not the ones providing it?
They are the ones providing the technology, but they're not carrying any tangible item which it's on. They're just going there to advise.
Okay, regarding let me talk to you a little offline about this one in more detail, if you don't mind. Then I can sit down and go through these provisions with you.
Okay, great. Thank you.
And what's the best way for them to get in touch with you? Should they call the BIS promotion outreach line? What's the best number to call you, to email you directly, or how will this gentleman be able to?
They can call the Regulatory Policy Division, also our colleagues in outreach, and I can give them two numbers, but either way they can get to me or someone within our organization. And what's
the number? 202-482?
For the Regulatory Policy Division, 2440.
2440. So once again,
202-482-2440. Or let me give you my email.
Okay.
SQUARTER@bis.doc.gov.
And I would repeat that again. So your email again is
SQUARTER@bis.doc.gov.
Great, thank you.
Thank you, Sheila. Thank you for your question. Okay, while we're waiting here for more voice questions, I have another question, written question from Loretta Sabo. If 90% of universities are conducting fundamental research, do you need to be concerned about looking at the CCL to verify what the end use and end user is?
Well, now there are some exemptions, or there are some, let's put it this way, there are certain parameters or less restrictive provisions under the EAR for fundamental research. In fact, I'm going to lead you to Part 734 under the EAR regarding fundamental research. And I understand your question, because a lot of the concerns about fundamental research or universities engaged in research with foreign nationals becomes a really big issue under the EAR. But if you have 90% of universities are conducting fundamental research, you need to be concerned about looking at the CCL to verify what the end use and end user is. Now, let's make sure you have separated CCL from end use and end user. I understand the concern about what universities are doing, and a lot of them are doing great work. They're concerned about the transfer of information that will allow others, especially foreign nationals, to either develop and produce certain items that might otherwise be controlled under the EAR. If you are concerned about the Commerce Control List, then we would suggest that information that is going to be imparted to those who are working at the universities would then get, submit to us a classification request, because you want to make sure that whatever is going to be exchanged is not controlled under the EAR. You separate that from end use and end user if it is not listed on the CCL, if what you're exchanging or developing is not on the CCL, then what we're talking about then is the end use and end user controls. That's because the item or the information is not listed and there's no presumption of a license requirement. So first, I'd like for you to be a little clear as to if you're talking about foreign nationals working at the universities, there may be some concern about the intellectual property that's transferred, and because for our purposes under what we call deemed export, if for those of you who are familiar and those who are not, the deemed export under the EAR is where information communicated to in such a way or transferred to a foreign national in the United States is like transferring it or sending it to that individual's home country. And in that case, if it required a license to Spain, then if you're dealing with a foreign national in your university and they are getting information for purposes of development and production, or they could go back to their home country and build something or create something on that basis, you might have some concerns. So I think you do have concerns, but only to the extent that there's no exemption for you, perhaps under 734 as it relates to fundamental research. Otherwise, I would suggest that you go ahead and evaluate the nature of the information to be transferred. And one of my colleagues has been nice enough to find the exact citation in the EAR, and that would be 738.8, information resulting from fundamental research. And if you have any more detailed questions, I can guide you to one of our great experts in our program of licensing officers regarding deemed exports. And call me, 202-482-2440, or some of my other colleagues like Angela Robinson in Outreach, 202-482-4811, and we can get you to our program experts. So I hope that helps you.
Okay, one last time for any voice questions.
We do have one question in queue. Loretta Sabo, your line is open.
You just answered it because I submitted it in writing for the fundamental research and the end use and end user. I was just confused as to is it being proactive to look at those things, to review the foreign nationals. It was my understanding that if it's fundamental research, then it does not apply.
And that's why I can't tell you under your fact pattern or your circumstances, but guiding you to the criteria, if you have determined under the criteria does not apply, then congratulations. We're always happy if we can find a carve-out for you, but we want you to be careful about what the guidance provides and if you met all the conditions. So if you got any other questions, though, about any new, information or questions that you're submitting to the agency, just let us know.
Okay, thank you so much.
At this time, there are no further questions.
Okay, well then that concludes our today's presentation. For those of you who might have questions later on, please remember the contact information that Sheila gave out, and you can email her or contact her, or the BIS's main direct line for counseling. Also, I'd like to give everybody a thank you for participating in today's webinar. Like always, thank you for your interest and thank you for your questions. I'd also like to give a great thank you to Sheila Quarterman for her expertise on today's subject. Also, I'd like to let everybody know to please check out the website for the Bureau of Industry and Security at www.bis.doc.gov, where you can get more information on this topic. Also, I'd like you to also look at the U.S. Commercial Services website, www.export.gov. And in that website, there is the announcement of all these webinars in this series. This is a 9-webinar series. We, I think, have now concluded now the 5th one, and we are going forward with the remaining. So if you still are interested in the topics for this series, which are related to one another, go to export.gov, www.export.gov, and in the middle of the page, you'll see a link that asks for you to type in your information and register for the upcoming webinars. Thank you, everybody, for joining us, and please check your email boxes for more information on upcoming events. Thank you, and goodbye.
This concludes today's conference. Thank you for your participation. You may disconnect at this time.